All right, so let's begin. How to avoid hiring pitfalls for February 19th of 2013. Here's the agenda that we're going to be covering in the next 45 minutes or so. First, we're going to look at basic interviewing rules, kind of the do's and don'ts. And we're going to look at the Fair Credit Reporting Act. There has been some activity. Probably you're all aware of that. But if not, we'll bring you up to speed on what's important for you to know there. There's a concept that's sort of emerged in the ethos of interviewing called narrow bracketing, and it's something you kind of want to stay away from. It poses a potential discrimination problem for you. So we'll talk about beware of narrow bracketing. Then we're going to look at structured interviews versus non-structured interviews, the pros and cons of each, and kind of which one is, well, I'll let you make the decision on which one's better. Employment tests. There's always new stuff happening on employment tests, and so we're going to cover that area as well. They're terrific for looking at things that there's just no way the best interviewer could get out of a person because you can't get inside of their head and their thoughts. But the tests can, and they're remarkably refined. We'll look at drug testing. We're going to take a look at a really big problem that I've talked about for some years, and it's the email problem. And if you haven't heard this problem, you'll definitely want to make sure you stick around at least for that part, because it is a big problem, and it's one that becomes your problem as an employer. And then ultimately we'll look at what does the offer to the employee, the prospective employee, look like, and how that works. So without further ado, let's get going here. Now, these are the interviewing rules that we really want to cover. We do have a bias, and the bias is that we should be using structured interviews, structured questionnaires. The reason you want to use a structured questionnaire, I hate them. I do not like to do it that way. I'd rather look at the candidate's resume and wrap my questions around the candidate. But there's a problem with that. I know how to do an interview, and I'll bet you all of you do as well. But a lot of the people who work in your company, if they ever do interviews, they're not learned necessarily in how to do an interview. And so you run into these kinds of problems. It's a he said, she said kind of a thing. The person doing the interviewing, something might, in a non-structured interview, they may slip up and say, I tell you, some of them, they're just crazy. Are you pregnant? Well, no, that's pretty much a trip to the court. But questions that are discriminatory, questions that are just out of bounds, things like that. Now, even if the question is not asked in an unstructured interview, if the interview goes awry, or if the candidate that you're interviewing is kind of a tough person, tough cookie of an interviewee, and that person, he or she, didn't like how he or she was treated, it happens where they go out and they make a legal stink for you and accuse you of saying certain things. The question is, when you have an unstructured questionnaire, how do you prove? You have no defense unless you recorded the interview. But nobody does that. So you really would not have much of a defense. And so even though you were innocent and did nothing wrong, probably, you can't prove it. And so you end up spending a lot of money defending a frivolous lawsuit. Now, it's quite the opposite the way the courts and a plaintiff's attorney that may want to come after you over some bad interview. If you use a structured questionnaire, well, then it's like, well, okay, here's what we talked about. I don't know what he or she was talking about, but here are the questions that I asked. And you lay that out. Here it is. This is what I ask every single candidate that we've interviewed over this period of time, whatever that might be. Everybody got the same questions. And you know what? You can go and interview those people and find out if I've asked those questions. And that's kind of really put a damper on a legal assault that's coming at you. So a structured questionnaire does a couple things. It helps avoid the possibility of asking discriminatory questions of people that are not necessarily good interviewers. But number two, and even more importantly, it is a defense, because you just never know when somebody's going to come after you over an interview. We live in a very litigious society, and this is a litigious area. So use structured questionnaires. Number two, use zinger questions. Put these in your structured questionnaire. What you want to do is put the interviewee off guard. I have some friends that work at Microsoft Corporation, and a number of them actually, and every one of them, when they've interviewed they all work in different types of jobs there, but when they interview, the recruiter that is the first point of contact at Microsoft, they'll go through an interview and they'll ask questions like, how do you see the similarity between a white pine tree and a sewer drain? And the whole idea that there really isn't a relationship there, but what they're going to get is they want to see how clever the interviewee is at trying to be under pressure, trying to come up with some halfway decent answer, and see if they can creatively put something together, because it'll be telling in terms of how creative their answer is, or if they're just sort of like brain dead or something and they can't really come up with anything. So zinger questions can be used very effectively as long as they're not discriminatory, because they get the person off guard, and that can be very revealing in terms of the candidate. So use zinger questions in your interviews. Beg your pardon. Number three, do not ask any question that does not apply directly to the job at hand. That goes hand in hand with the fourth point, which is do not ask any question that is discriminatory under Title VII of the Civil Rights Act of 1964. The reason is because of a law called Supreme Court ruling, U.S. Supreme Court, called Griggs versus Duke Power. Griggs versus Duke Power, here's what happened. Duke Power, which is a power utility in the southeast part of the country, and Duke Power, everybody at one time that would come and want to work for Duke Power would have to take a general aptitude test. And they'd ask a number of things, try and get a gauge on your knowledge of English and writing samples. And there was a math part. There was a math section. Well, there was a guy named Griggs, and Griggs and a buddy of his, there were two guys. This is a very poor area of the country. It's a very impoverished area. It's not a place where people have lots of education. They don't have lots of money. They're great people. They just are disadvantaged in that respect. And so Griggs and his buddy saw an ad in the paper, and they decided to go to Duke Power. And they apply there, and they said, well, we have a standard test. Everybody from the CEO down to anybody takes this test. So here's the test. They give them the test. Now, the job they were applying for, if I remember correctly, was something like a groundskeeper position or a couple positions open, and that's what they were applying for. Now, you might ask yourself, well, what is being a groundskeeper and maybe shoveling snow or, keeping the flower beds looking nice have to do with algebra or geometry or calculus? Well, probably not a whole lot at all, but some of those questions were on the test. Now, it's a nuclear power plant. I suppose the nuclear scientists they'd want to know if they can at least do that part. But it didn't apply to these particular two fellas who were trying to get a job. So they failed the test, and they failed the math component, and they did not proceed any further in the interview. And Mr. Griggs in particular thought, well, that was a raw deal, and felt that just didn't seem fair. Why do we have to know that stuff? We'll never use that in the job that they were applying for. And Mr. Griggs took that through the courts, ultimately reached the U.S. Supreme Court. And the U.S. Supreme Court said a number of things about Griggs versus Duke Power. Number one, they ruled in favor of Griggs and against Duke Power. And this is what they said. They said that in any employment interview, you cannot ask any question that does not directly relate to the job for which the interviewee is applying. No questions that do not specifically relate to the job for which they're applying. It says something else. It says that you can't administer any employment test that has any questions that do not directly relate to the job for which the candidate is applying. So the tests, the questions, the whole thing must relate to the job that that candidate is applying. And if that's not the case, then you have a situation where you are probably creating something called disparate impact. Disparate impact. Disparate impact is unintentional discrimination against a protected class. That's what it is. Falls under Title VII. That's where the other point comes into play. So that's not something you want to do. So make sure that whoever does your hiring managers, that the questions they ask are directly related to the job. And if there's an employment test or any kind of a test as part of the interviewing process, that the questions must only be asked as they relate to the job. Document your answers. Document your answers in your interviewing. So if you're using a structured questionnaire, or if you prefer to go out on a little walk on the wild side and decide to ask questions that, like I like to do, make sure you document the answers that the candidate gives you, because you never know when that's going to come back legally and try and hurt you. The last point is have candidates complete an EEO-1 employment application, even if they have a curriculum vitae or a resume that they've sent in. Now, the reason you want to do that is, excuse me, one ahead too far there. The EEO-1 employment application is a formal accounting of an interviewee's information. It's a standardized form. It's something that asks for certain things. Should you ever be found to be discriminatory and have a court come after you and slap an affirmative action program upon you, those employment applications are going to be a very good defense. They're going to help you. So it's not that big of a deal. It's just something put into your practice. Anytime somebody comes in, boom, the first thing they get, here, fill out this application. There's a desk, here's a pencil, fill it out, and then we'll take it from there. So you may have the resume, but also have the EEO-1 employment application with you. Okay, there's been some action on the Fair Credit Reporting Act. Probably it's a little, we're in February here, so hopefully you did all this already back on January 1. Beginning on January 1 of 2013, employers must use, now it's past tense, you should have been using, the revised forms issued by the Consumer Financial Protection Bureau to conduct background checks under the FCRA. So if you do background checks, there's a couple little twists that are not complicated, but they're the law, and they're things that you have to do. Now there are some new, pardon me, there are some new forms that also come along with this requirement. One of the forms is a summary of the employee's rights under the Fair Credit Reporting Act, and they must give that to the person who's getting a background check. The employers must provide that form to any employee prior to taking an adverse employment action based on a consumer report. So it's for people that you are hiring and you do a background check, but you might have a policy in your handbook that allows you to take random background checks on your existing employees. But before you do that, you have to give that employee the form, and you're in essence going to be tipping them off that you are going to be doing this check of their credit. And the credit, the reason you do that is because it can be, depending on the position that they're in, it can be very telling of how responsible they are, and then you can kind of measure that against the kind of job in terms of what kind of responsibility are you giving them, and are they responsible enough to handle that. Number two is that you have to provide a notice to furnishers of information. Anybody that's giving you a background check or is giving you credit information, you have to provide a notice to them. And the obligation of the furnishers under the federal, the Fair Credit Reporting Act. So we're not going to assume that the people that are giving you information that you're working with on the credit side know this. They should know this. They better know this, but you can't assume that they know this. And so the law is saying that you have an obligation to tell them of their rights and responsibilities under the Fair Credit Reporting Act. Last point, there's a notice to users of consumer reports. There's an obligation of users under the Fair Credit Reporting Act. And all that information is already available in Future Office Network. And you can just go in there and type in FCRA under one of the search engines, and it'll bring up all the stuff, and it's a 2-minute job. Anyway, those are the things that went into effect on January 1 of 2013. Make sure you're up to speed on that part, because if you're not, that could be a fine. Beware of narrow bracketing. Beware of narrow bracketing. Let me just kind of read you. This is really kind of more of a theory, and here's how it goes. The theory was that a phenomenon called narrow bracketing was affecting how those, this is some stuff I got from the Wharton School, University of Pennsylvania, and it was that narrow bracketing was affecting how those late-day candidates, people late in the day, you've been interviewing all day and you got the last one of the day, you're tired, they're tired. Put simply, narrow bracketing is when an individual makes a decision without taking into account the consequences of many similar choices. At the roulette wheel, a gambler who knows that the wheel's odds of turning up red or black are 50-50 will look at the day's results, which are often displayed by the casino, and predict a certain color, even though a subset of the spins is not necessarily representative of the expected overall distribution. On a 5-point scale, with 5 being the best possible score, a similarly qualified applicant who interviewed on the tail end of his top-scoring competition got lower scores overall than what he or she would have otherwise received had he or she been interviewed earlier during the day. It's just kind of one of those strange behavioral things that happens. And we've discovered this. So conversely, those who interviewed after a group of weaker competitors got better than expected evaluations. This is a bias. This is a new bias that we've discovered, and it's something that we all should be aware of, because bias leads to discrimination, and that leads to fines. The data covered more than 9,000 interviews done by 31 interviewers, none of whom were connected with the school. So it was a fairly decent study. So narrow bracketing is this theory affecting how late-day candidates will be judged. And usually they don't get exactly the fairest shake as somebody, perhaps first in the morning or a couple of interviews into the day. If you're a recruiter, and you just got a full day of interviews scheduled, you're going to go through that. Let's face it, for any of us, it gets a little bit monotonous after doing that, and they all kind of start to bleed together. So narrow bracketing is a concept that you might want to think about. Employment tests. Well, we've already talked about U.S. Supreme Court Griggs versus Duke Power and the concept of adverse impact, and another one called adverse treatment. And so you don't want to ask any question on any employment tests or in any interview that is not directly related to the job for which the person is applying for. Now, that also carries through to your current employees. Do not make a hiring decision or a promotion decision based solely on the results of an employment test. That is illegal. Now, the weird thing is that these tests, some of them that we use when we do HR for companies, some of the tests that we use they're so sophisticated, And the reliability factor is so strong as far as predicting behavior of the candidate in that job. That, it is, I tell you, it is tempting to go, you see one after another and they're like right on the money. It's so tempting to say, well, I'm not even going to rely on my interviewing skills. I'm just going to give them the test, what the test says, reject or accept, and look at some of the score points. I'm going to go on what the test tells me to do. But that's illegal. You can only use employment test results as a part of your criteria in making a hiring decision or a decision to promote or fire somebody, to terminate somebody who's already on your staff. You use employment tests to understand behaviors because we know that behaviors lead to job satisfaction. They lead to productivity or a loss of productivity. It's all about behaviors. So they will predict those behaviors fairly reliably. Last thing, you use employment tests for that all-important job fit. That when we interview people, we're always trying to find that good job fit. And sometimes it's so elusive, it's hard to really get your hands around. Employment test is very good for that. It'll say, particularly if you have the tests on some of the other people that they're going to be working with, they can then compare those and say, you know what, you've got the makings of a really good team here. These people are complementary in their personalities. They're complementary in their strengths and in their weaknesses. One's going to cover the strengths, the weaknesses of another, and that sort of thing. So employment tests are very, very good for that, and the prices come down considerably. Drug testing. Urine versus hair testing, which is pretty much the two primary ways that we do testing. If you do drug testing, there's a couple of things that you need to do legally. Number one is you need to have your drug testing privileges that you can do in your employee handbook. You have to give yourself permission to do what that is. Number three, you administer drug testing consistently and uniformly in recruiting. You can't do it, for this person but not for that person. That's gonna, it's not going to pass the smell test, and you're technically discriminating against somebody by making them do something that somebody else doesn't have to do. Now, with regard to urine testing or hair testing, hair testing is this is not a new concept, so I'm kind of hedging my bets here by talking this way, because I realize probably everybody knows this, but just in case you don't, urine testing is the most popular, but it doesn't necessarily catch everything or the detail of illicit drugs that hair testing does. One piece of hair off anywhere on somebody's body, and that hair will hold the contents, the compounds of illicit drugs, illicit substances, much, much longer, weeks longer than a urine sample would. So that's the value there. So if somebody even a few months ago, a few weeks ago, was abusing substances, and they go, well, I got to clean myself up because I got this interview coming up. Well, you do the testing of the hair, it's probably going to still show up. The last point here on the bullet is administer drug testing only after an employment offer has been extended. That is a federal rule. You cannot say, take a drug test and then we'll talk. No, you have to offer them a job and then basically tell them this. We're offering you this position. We think you're the best candidate for it. But before we consummate the hire, we want you to submit to a drug testing. Is that okay? And they'll say, yes, that's okay, or they won't say that's okay. If they say that's okay, then they go and they take the drug test. And you, in essence, made the actual hiring date contingent upon successful passage of the drug test. If they pass the test, well, that was the last hurdle to go through, and they're hired. That's how it does. But you have to make an offer before you administer any drug testing to any candidate. the email problem with hiring. I know of an employer, and I was brought into this one kind of late. Here's what happened, and it probably mirrors what happens to so many companies, perhaps your company. This employer received an unsolicited resume. This is a company in Milwaukee, Wisconsin. They received an unsolicited resume from a woman who wanted to work there. And she sent her resume to directly, she bypassed HR and all that kind of thing, and sent it directly to the hiring manager in the department that she wanted to work. And he was an executive. And she was a fairly high-powered person herself. And the executive got the email, and he decided to take a look at it, and he says, wow, there's really something kind of interesting. I think I'd like to talk with her. So what does he do? He emails back to her as a reply. He replies to her initial email that she initiated, and says, I'd like to come and chat with you, have a cup of coffee. Just, we don't have any openings right now, but you never know. See where things go. Well, those kind of things. And so she then replied to the reply, which was to her reply. You follow me? And she came in. Well, this went on for about 6 weeks. And ultimately, she was hired, and she was a highly compensated employee. And in the emails, at one point, she had proffered a severance agreement, at least the language of a severance agreement, saying if things should go awry, go wrong, this is what I would like, this much vacation, this much money to separate, this kind of thing. Now, here's the problem. The employer did not respond to that specific piece of content. So when he replied, it was almost like he ignored it, but it was in line of all these reply to reply to reply. It was literally for 6 weeks, basically one continuous email back and forth. Ultimately, she was hired. 3 months later, she didn't work out. She was fired. And that's when I got involved. And the employer said, she's got this wrongful dismissal suit, which is sort of the obligatory lawsuit. But she has this other thing that our lawyers said we should be kind of concerned about. And I said, well, what's that? She says, well, it's a severance pay policy. And I says, well, what's the deal about that? And she said, and the employer said, well, we don't have a severance pay plan. We've never paid severance here before. And I said, well, she's getting that from somewhere. I mean, where's it coming from? At this point, I didn't know about how this person was hired. And then, digging a little bit deeper, I said, well, let's just kind of bring it all out here and find out how she was hired. How did she come in contact with you? How was she interviewed? All that stuff. And that's when I discovered this in essence, one long, really long email. And because it was reply to reply, it was legally, all the messages were connected to one another. And I said, I think you got a problem here. Because when the severance thing, I found the little severance email, and I said, when she proffered this severance formula to you, you did not say no. You didn't say yes, but you didn't say no. And it kind of got assumed. And so what in essence happened, and it did go to court, and the employer lost. They lost a lot of money because the judge ruled that what in effect had happened was there was an implied contract. She applies, company responds, normal horse trading over vacation and benefits and all that kind of stuff. And then there's this severance pay formula, which they did comment on, saying, well, I can't do vacation, but I can do this and this and the car and all this. All of that stuff they haggled over, but they did not choose to haggle over the severance pay plan. So by default, it was as if it was accepted, and that's what the court ruled. And that severance pay check that she got was $50,000, and that's a true story. I don't want that to be a true story for you, my friends. So the best thing to do is tell your hiring managers that any emails that they get that are unsolicited with resumes, or even if you're running ads and their people are playing tricks, they want to bypass HR and talk to the decision maker, that kind of stuff. Tell your hiring managers that all resumes or all inquiries about a job need to go to a single point of contact, the person who handles the HR in your organization, and have them know this little incident that I just explained to you. Do not allow email to be a proxy for in-person application. Tell the candidate that. Say, look, if you're interested in here, we don't have a job for you, or we do have a job opening here, we don't know, but whatever it is, if you're interested in our company, we will not talk to you any further until you come in person and complete an EEO-1 application. That's it. Sounds really tough, but it's all about what is happening out there in the courts and how to protect you, and that's where we come in. We want to protect you. Okay, the offer. So now things have gone well. You've sifted through a number of people's writings, and you make an offer. Number one, the offer should be in writing. I recommend you don't do this in email. It's better if you do this through snail mail with the Postal Service. Why? Because it can't get lost. Send a certified mail. I mean, this is a serious event. And so make the offer in writing and mail it to the candidate. You can tell them on the phone that it's coming and what's involved, but give it to them in writing. Number two, in the letter. Now, a lot of companies don't do this. They put this in the handbook, and that's a good place for it, but you should put this in the actual offer, the letter of offer of employment, the at-will doctrine. State that, we're offering you this job, your employment is at will. That means, tell them what it means. It means that you can quit at any time, and we can terminate you at any time. It's not friendly language, it's not a love fest, it's not happy talk, but it's legal stuff that's going to protect you. The offer should include all terms, all conditions negotiated during pre-employment. All that should be in the offer letter. It's one tight little package. Now, if some firms, and maybe your firm does this, if you offer a probation period to employees to kind of, maybe there's a probation wage or whatever, you just want to see if they're going to kind of work out. Well, a lot of companies like to use that, but there's a lot of case law out there right now where employees that were hired on a probationary period, and then after the probationary period, they were let go. And what did they do? They went to the lawyer, they went to the court, and the court said, well, probation, when you satisfied the probationary period, one could construe that you were like home free. In other words, there was some kind of quasi-guarantee of some kind of future employment because you passed the probationary period. Well, I don't think anybody on this call is thinking that. So make sure that if you do offer a probationary period, put that in the letter and have the letter state as follows. Successful completion of the probationary period is no guarantee of future employment or permanent employment, and that will save you a lot of pain down the way. Good luck with your new hire, and now I'll take any questions that anybody has. So raise your hand if you've got a question, and I'll call on you. Or if you have a question you want to write in, you can do that too, and I'll give you a couple seconds to do that. Okay, let me just, okay, hi Barb, I just opened up your phone and I see you raised your hand. Did you have a question?
Actually, this is Steve. I'm in Barb's office.
Hi, Steve.
It wasn't
Sorry, Val.
Yeah. So I have a question about the correlation between the question that kind of throws people off, the zinger questions,
yeah,
and how it directly correlates to the work that someone's going to be doing.
Mm-hmm.
How can we utilize those zinger questions and not get caught up in the legality of it having to be directly correlated to the person's position?
Yeah. Yeah, that's a very good question. Here's the answer. The methodology of using difficult questions, or what I call zinger questions, is that it relates to every job that anybody would apply for, because what you're doing is, let's assume that every job that somebody applies for, one of the things that they have to do in that job is think. They have to think. And sometimes they have to think abstract. Sometimes they need to think about complex things. Sometimes they need to think about all kinds of stuff at one time. But by asking those zinger questions, what you're doing is it relates literally to every job that you have, because what you're doing there, the purpose of the question, it may sound like just a crazy, dumb question, but it throws the ball to the interviewee and causes them to think. And then they have to speak the words of their thoughts. So it gives you an opportunity to say, are we dealing with somebody that's really kind of sharp here, or are they kind of a simpleton of an interviewee and really don't have a very good response to the question? So it is always going to be fair game, because you're simply asking them to show them how they process their thoughts, because in every job you got to process thoughts. That's your answer.
Thank you.
Thank you, Steve. Thank you, Barb.
You're welcome.
Okay, let's see if we have any other questions here. Hands up, looking for those hands. Let's see if we have any questions that people wrote in down here on the bottom. Well, I don't see any questions there. One more pass and see if we have got hands up. Your last chance, guys. Oh, we got Steve, did you have another question, or Barb?
No, it's Barb this time.
Oh, hi, Barb.
Hi. My question is, on here it states that we should avoid accepting resumes via email.
Yes.
What is your recommendation?
My recommendation is that they mail them to you. We all understand. It is so simple to have a resume, and everybody does it. But there are problems with email. Not that you're getting the resume in email. The question is, what's the very next thing you're going to do with the email? What are you going to do with it? And that's where you start getting into some strange things. Are you going to respond to the candidate? Well, then you start running up that risk of an implied contract, which I learned so acutely. So it's not probably practical in our email-happy smartphone world, but just write them back saying we do not accept applications. Pardon me, we do not accept resumes or job inquiries via email. Our address is as follows. Put it in the mail. That's a safer way to do it, because then you have a legitimate hard copy.
Okay.
That's the reason why. Because once you get an email, just think about it. You're probably not going to print it out. You might, but you're going to email it to somebody else. Somebody else is going to get a hold of that, and that person then might respond to the candidate. It just opens like kind of a web that maybe you can't control.
Sure. And I know I have another really quick question in regards to email.
Please.
If you interview an applicant and you decide that applicant isn't what you're looking for,
yes,
do you email them and tell them that, or do you send it in the mail?
It's a class. It's how classy do you want to be? You can send an email. Some people interpret that as kind of cheap. Realizing, of course, that a lot of times people apply for positions, especially in the market that we have today and have had for a number of years, where we have fairly high unemployment. People never even hear back from an employer, so they're glad to at least hear closure. So an email can be good for that. I'll just speak from personal experience. I mean, when I was at a certain point in my life applying for jobs, I always at least felt good about the company when they would email, pardon me, when they would mail me on their card, on their letterhead, dear John, appreciate all your accomplishments and blah 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 blah. We selected somebody that best met our needs, and it was that kind of letter. But at least they took the time to put it in on their letterhead and send it to me. I felt at least good about the company. Mm-hmm. I think that's always a good thing. An email is kind of cheap.
Mm-hmm. Okay, thank you.
Thank you, Barb. Okay, let's see if we have any other questions here. We're on a roll. All right. And no other questions there. So I guess what I'm going to do is, if you have any questions or if you need any help at any given time, just contact us. This will come through directly to me. Support@yourfutureoffice.com. Support@yourfutureoffice.com. Fill out the evaluations. It'll be in your inbox, my friends. And tell some friends these are free. So if you have friends at other companies, you're welcome to share the invitations with them. This is a service that we provide to the public. So fill out the evaluation so we know how we're doing and how we can improve. We'd very much like to know that. And by that, I would say thank you very much for letting me have some of your time today. We're right on the money. We're 1 minute shy of 45 minutes. Thank you, everybody, and have yourselves a good day.